the land ordinance. Okay, bear in mind that this was actually enacted in 1930. Okay, this was actually even before the Second World War. I just want to run through some key definitions. Abandonment means the failure on the part of any holder of a title to land. Look again, we're not talking about you're the owner of the land, you're the holder of the title of land. To use such land for the purpose for which it was alienated for such period and to such extent as may be prescribed in each case. I will come to this in a while. Then charge means any charge created on the land for the purpose of securing the payment of money, and also the instrument by which the charge is created. Dealing. This is a very important definition. Dealing means any transaction of whatever nature by which land is affected under this ordinance. Okay, this is very important. The key dealings are transfer, sublease, and charge. This word dealing has a greater significance when we come to discuss about caveats later on. Foreshore is where we are talking about seafront land. Foreshore is defined as a land line between the high water mark and the low water mark of ordinary spring tides. This is an important definition. What is actually land? Land, the surface of the earth and all substances forming that surface. So you're only entitled to surface rights. The earth below the surface and all substances therein. This is broad definition of land. This may sound contradictory to what I said earlier, that land, definition of land includes all the earth below the surface and all substances therein. This is the definition of land, but subsequently there's another section which says you're only entitled to surface rights. All vegetation and other natural products, whether or not requiring the periodical application of labor to the production, all things attached to the earth or permanently fastened to anything attached to the earth, whether on or below the surface. This definition is important because in our land ordinance, we do not have a distinction between the house that's built on the land and the land itself. So if you actually have a house, if you sell the land, because the land is defined to include all things which are permanently fastened to it, when you sell the land, the house goes together with it. Okay, you cannot sell the house separately from the land. Okay? Includes land covered by water, which means you have those in your respective towns. You may have a kampung air, and those houses in the kampung air may have documents of title. Any bed of any river, stream, lake, or watercourse, any area of the continental shelf, being the seabed and its subsoil which lies beneath the high seas contiguous to the territorial waters. Okay, so this one you seldom come to your desk when you're practicing, but the more important things are rivers, land covered with water. This you deal with it every time you deal with land without actually knowing it, because a factory, a house, a shed, whatever that's been built on the piece of land, or a pond, a concrete pond, a swimming pool, is permanently attached to the land, and when you sell the land, it goes with it. Okay? Lease means any lease of land given on behalf of the government. So your titles are all leases. Memorandum, when we coming back to our definition of dealing, all dealings are done by way of a memorandum of transfer, a memorandum of sublease, or memorandum of charge. And all these are called memorandum, and then it is not my invention, it's not any lawyer's invention. All these memorandum are found in the schedule to the land ordinance. We have native title, then owner. So, as I mentioned just now, when you say you're the owner of the land, what do you actually own? Owner means the individual person, incorporated company or body corporate, for the time being registered as the lessee of state land. You're the registered lessee of the state land. But this definition allows you to call yourself the owner of the land. But what you're actually owning is you own by way of being registered as a lessee of land. In the case of native title or field register, you delete or goes on cover trustees, executors, administrator, liquidator, or the OR. While we are here, I will just mention very quickly about native title and field register. Field register is also a form of native title. The distinction between native title and field register is that they are also a kind of lease. It's also in the form of lease by the state government to the native. The difference here is that there's no tenure. There's no 99 years, there's no 999 years, there's no 60 years. Why? Because it is assumed constitutionally that these natives became owner of these lands by virtue of native customary rights on the basis that their ancestors and their pre-ancestors have subsisted or cultivated this land for long years, and as part of the colonization of North Borneo, this law was created to protect the interests of natives, the pre-existing natives on the lands. So the distinction between native titles and leases is that native titles do not have a tenure, but they're still subject to payment of annual rent. The native title itself has a map to indicate where the location of the land is, and then you can create a charge sublease over native title just as you can over a sublease. As I mentioned earlier just now, Section 5, the entire property in and control of state land or land reserved for a public purpose is and shall be vested solely in the government. So all the land in Sabah is basically state land. And when they alienate the land to you, they alienate only a lease to you. Just because you occupy state land does not give you any rights. Some of you may have graduated from UK or other jurisdictions where you may have adverse possession, where if you occupy land long enough, you have squatter rights and people cannot kick you out. That doesn't happen in Sabah. The law is very clear. Unlawful occupation, not to establish any rights. Classification of land. Section 9 talks about alienation of land. So for the purpose of the exam, you just need to know the key principles of this part. You don't really need to know the exact details, like what's the exact procedure to actually apply for land and all this. You just need to know the key issues: state land, interest in land, leases. The only part which you need to know in some great detail, which I'll point you later on, is the part relating to registration. Okay, we'll jump down to Section 17. Section 17 is very important. This is one section you must know, and this relates to native titles. Basically, it says that a non-native cannot acquire any interest in a native title, okay, except with the written permission of the minister. The minister here refers to the Minister of Natural Resources, which is the Chief Minister. All dealings in land between non-natives on the one hand and natives on the other are hereby expressly forbidden, and no such dealing shall be valid or shall be recognized in any court of law. Okay, so together with Section 17, I'm going to jump to Section 4 relates to native lands. In addition to what we covered just now in Section 17, please also note this. Notwithstanding the provisions of any written law, any power of attorney whereof the donee of the donee is a non-native, if it relates to land held under this part, shall be null and void. So if you happen to be a native, you are a native guy or you are a native girl, and your boyfriend is a Chinese, and you happen to have some native title, and you want your boyfriend to to develop the land, or you want to sell the land to your Chinese boyfriend, under Section 17, you cannot do that. It is expressly prohibited. Secondly, okay, you cannot transfer it to your boyfriend, so you give him a power of attorney to deal with the land. Section 64(2) prohibits that as well. Okay? I will come later to that, but I will just mention it now. That when we come to talk about this kind of power of attorney, only if it relates to land. If you are a native girl and you want to give a power of attorney to your Chinese boyfriend to deal with your motor car, or to deal with your jewelry, or to ask him to do something else which is not related to native title, that's okay, that's fine, that power of attorney is valid. But if it relates to native title, it is null and void. If you are the owner of a country lease, nothing to do with native title, nothing wrong with you as a native giving a power of attorney over your country lease in favor of your Chinese boyfriend. Okay, I hope that illustrates the point. We'll go back to. Okay. Just now I mentioned that every title comes with implied terms and conditions. So, in addition to the express terms which you can see in every document of title, you will also have all these implied terms in this 29 orders. You probably need to go and try to remember this, particularly Section 30, specific rights reserved. The following specific rights are reserved to the government. So, whoever owns the document of title, although the document of title is very short, just 2 or 3 pages, all these are implied into the document of title. First one, the right for the government to remove timber, earth, stone, clay, sand, right of making drains, sewers, irrigation wells, water pipes, telegraph wires, without paying compensation. Okay? Only proviso is that if the work interfere with any building on your land, compensation shall be allowed for disturbance or damage. So the government has been paying compensation to kampung people if, for instance, the drain or the electric wire results in the damage of their mango tree or durian plantation. The government has been paying compensation, and this comes under this proviso. This one was enacted only not too long ago for the construction of pylons, elastic pylons, for the elastic grid for Sabah. The right to resume without payment any from any land held under provisional lease or field register, a section not exceeding 20 meters in width for the purpose of making any public road, farmway, okay, cause any tree or alienated land to be felled, trimmed. So the town board or DBKK or MPK, Tawau Municipal Council can come to your land and cut down any tree which is causing any damage, and you cannot stop them because it is provided for under the law. Okay, I just want to go additional implied terms, conditions and titles, land revenue. The special significance about provisional lease and field register is mainly because the final survey for the land has not been done. So the exact boundary of a provisional lease or a native title in the form of a field register has not been clearly identified. So one day you decide to apply to convert your provisional lease to a proper country lease by doing a proper survey. You can do that. And if in the proper survey you find that your land is actually smaller than what is mentioned in your provisional lease title, you cannot claim for compensation. Because provisional lease tells you the boundaries were only provisional. Likewise, your field register, which is a native title, you cannot claim for compensation if one day you convert the field register to a native title by doing a proper survey and you find out that the land area is actually smaller. The right of way, this section you probably have to remember. Even I cannot recall whether there's an exam question on this, but it is something which you have to deal with regularly in practice. And this is in relation to the application for right of way over land. Okay? There is a few questions, I think maybe even two, on E. And I will explain E in greater detail. The owner of alienated land shall not commence any development on land which shall change the use of the land, except with the permission of the minister. Okay, there are questions on this subsection, so it's important for you to understand this. Okay, I will actually now deal with this key point.